Morning, everyone. This is the staff attorney for Judge Kraus. I expect her to be joining us momentarily. We have a pretty short calendar today. Um, I see Mr. Finnemore is here on the interpleader matter, and I saw Mr. Whitridge is here on the Headway Capital matter, and Mr. Knight here is on the EJ Capital LLC matter. Who do I have here on the Akil Sanders versus Errol Allen matter?
Stephen Robinson, representing Sergeant Sanders. This is myself, and this is my client, Sergeant Sanders.
All right, thank you very much. So we have counsel for every case on our calendar, so that's good. Judge will probably ask for a time announcement and take them in order. I believe the one that I believe number one, since there's going to be a damages hearing, will probably be the last one she takes, as she'll be able to dispose of the other three rather quickly. But I don't know what she'll do, so she'll be with us momentarily. I don't see a court reporter. So there's no issue there. And just look for Judge Rachel Kraus to.
Good morning, everyone.
Morning, Judge.
Okay, I have just a few matters on the calendar. First up is Akil Sanders versus Errol Allen.
Good morning, Your Honor. Stephen Robinson, representing the petitioner in this matter, and I have my client, Sergeant Sanders, with us.
Okay, thank you. And I believe this was a default matter. The other parties had been dismissed, and the only remaining party was Errol Sanders. Is that correct?
That is correct, Your Honor. It's a default matter. I'd say 15 minutes or less.
Okay, but there was the issue of damages, correct? And
Yes,
that's what you need to present on. Okay.
Yes, Your Honor.
And given that Mr. Flynn is in default, I assume you do not expect that he or counsel on his behalf are planning to appear?
I have not heard a single thing, Your Honor, from them.
Okay. Thank you, Mr. Robinson. I'll be with you in just a moment, okay?
Yes, Your Honor.
Thank you. Next up is Headway Capital versus Honan Property Management and Scott Honan.
Good morning, Your Honor. David Whitridge for the plaintiff.
Hi, Mr. Whitridge. So this is a default matter, but only as to the the Honan company, not Mr. Honan personally. Is that correct?
The corporate entity, correct. We've been able to serve the corporate entity. We're having a hard time finding, or not finding, but serving Mr. Honan. But yesterday we were able to, we actually located where he lives, but he's got a gated, no trespassing, so we're either, we've got to surmount that. And I think there's a order entered that we got to get that done or something done by the 29th. So
That's correct. Yes, Mr. Freehoff.
Yes, I just wanted to chime in. Mr. Whitridge, be aware that although that order is in place, if your diligent efforts are ongoing, contact the court, and the extension is always possible.
Sure.
So
Sure.
Right. I mean, and I think our order says, look, if you're trying to get them and you can't, let us know. But
given another 30 days, if you can demonstrate to the court that.
Well, it's interesting because he has an attorney and he's reached out to me and they said they would accept service. But that was probably about 4 weeks ago and they've gone radio silent. So I've been dinging them with emails and getting our private process server out there, but we'll submit something to the court before that date.
okay, thank you. Hold on just 1 second, okay?
Sure. No.
Apologize for the interruption. I am double dutying at the hospital with my sister and also trying to have this hearing, and medical professionals keep walking in and out. So I apologize for that interruption, and thank you for your patience. So next up I have the Sheriff's Department. Mitch, did I see correctly that we got a final order on that one?
Good morning, Your Honor. Stephen Finnemore on behalf of the Sheriff's Office.
Apparently I did not. Mr. Fenimore, how are you doing?
Thank you.
And what is your announcement on that one?
My announcement is that we filed the motion to deposit funds, motion for attorney's fees, and for the sheriff to be excused from further proceedings.
Okay. And my recollection is, and I appreciate, by the way, I saw your order, or it must have been your motion, but it very in great detail identifies all of the claimants that they were served and whether they answered, disclaimed, or did not answer. I super appreciate that. It makes everything so much easier. And I believe there was just, I'm sorry?
I appreciated the instructions, Your Honor. I'm going to use that, the order going forward.
Thank you. And then, so I think all we have to do then is make sure that we have the day's hearing, and I will have you just briefly present that as soon as we're sure that no one is going to be here to appear, and then we'll go from there. Okay?
Thank you, Your Honor.
And then last position I have, or not last, EJ Capital versus Rashida Bay.
Good morning, Your Honor. Brian Knight, on behalf of the plaintiff. This is a default hearing. We've served both Ms. Bay and the entity, and we're seeking to quiet title. And I've sent a proposed order to Mr. Freehoff.
And I saw that proposed order yesterday, and everything appeared to be in order. I am going to have you a few minutes to walk me through that process and the particulars of the defaults. If you do that, what, 5 minutes?
5
Mr.
minutes,
Knight?
Judge. Yep.
Okay, thank you. And last but not least, OTR Capital, or is this the one that resolved, Mr. Freehoff? Was it? It was moved, is that right? Mr. Freehoff, can you hear me? I think you might be frozen. Okay, so let's go ahead and go back to Mr. Robinson. Because your presentation takes about 15 minutes, I'm going to impose on you for about another 5 minutes to get these two gentlemen taken care of, and then you and your client will have my undivided attention, okay?
Do you mind if I step away and get a cup of coffee?
Not at all, sir. It is not, I'll make it easier for you. It's 9:11. Why don't you take a break, do whatever you need to do, and plan to be back in front of the camera at about 9:35.
Thank you, Your Honor.
Okay, thank you, sir.
Yep.
Okay, so we're going to start then with Headway Capital versus Honan Property, Mr. Whitridge.
Yes.
If you just sort of want to walk me through, as I said, I think you submitted a proposed order. But if you would just walk me through the basics of the default for the corporation. I saw that they were served through a registered agent.
Yes, the complaint was filed on October 19th, and the defendant, there's two defendants. There's Honan Property Management LLC and the guarantor, the principal of the company. The defendant, Honan Property Management, was properly served on November 14th, and then that proof of service was filed on November 21st, 23. The defendant is in default. They have not filed any answer to the pleadings. The underlying basis for the complaint is basically it's a line of credit, originally $60,000, and that at the time of the write-off it was $30,058.73. The defendant Honan Properties LLC has not responded. They have been served, and so we are asking for a judgment in the amount of $30,058.73, accrued interest of $12,123.04, and then post-judgment interest at 7%, and then attorney's fees of $4,243.18.
The attorney's fees are 13,111, is that right?
That's correct.
Okay. I don't think, I can have a hearing, which we're having now, or you can submit an affidavit in lieu of it under 13.1.
Okay.
If you can state in your place the basis for the fees. I don't necessarily have to assess reasonableness, I don't think, but.
Yes, if you will. I'm sorry, hang on. Oh, I'm in the wrong thing here. Why don't I do this? Probably the best thing to do is you've got other cases. Why don't I'll submit an affidavit to that extent, and then that way, obviously they could be awarded or denied based upon the affidavit that I submit.
Right, and my intention obviously is to grant you the relief that you seek, and the attorney's fees as a blanket matter appear facially to be reasonable under the circumstances, and they're sought under 13.1. So it's one of those things where I'm not even certain that it's required, given that it's a 13.111 presentation, but there's some discussion out there that the better course is just to always make sure that the attorney's fees are reasonable when I'm granting them. And so if you could submit, I mean, really just a very basic affidavit, we'll go ahead and get that order filed signed for you, Mr. Whitridge.
And well, you know, it probably just going forward, it might make sense just to submit that with the motion. So,
and honestly, if it's a 13.111 application, it's considered liquidated anyway. You don't even have to have a hearing. I can just grant it if everything's in order. So,
okay.
Okay.
All right. Sounds
Thank
good.
you, sir. Have a good day.
Thank you.
Okay, and next position is Mr. Winnemore, the Sheriff's Department versus Urban Residential Development.
Yes, thank you, Your Honor. This is
I'm sorry.
This is an interpleader case resulting from to dispense with funds obtained through a tax sale that happened in June of 2009. Not a whole lot of funds. It was $13,500, but a whole lot of claimants. So I do think it was worthwhile going through the exercise, making sure everyone was served. Imagine Your Honor doesn't want to go through each defendant and service, but
no, and you've made it very clear in the order, and I do appreciate that.
Thank you. The only respondent was the Fulton County Tax Commissioner, which I believe subsequently now has submitted a consent order stating no claim. They also answered no claim. That was the only answer. The only person who answered said that they didn't have any interest in the funds. We filed an affidavit of attorney's fees. We're seeking a flat fee of $2,500 for all the work involved, plus costs of $2,255.41. The costs are very high, but that is because of the number of defendants involved in the case and serving them all. I would state that the $4,755.41 is reasonable, and they are authorized pursuant to OCGA 48-4-5B.
Okay.
At this time, I would request that the court enter an order allowing us to have the sheriff deposit the funds with the registry of the court, then having the court cut a check to my office for the reasonable attorney's fees incurred by the sheriff, and then to have the remaining $4,457.54 remain in the court registry, at least for the next 5 years, unless somebody claims them, in which case, if not, then it was just this cheap to the state.
Okay, exactly. Yeah, I have reviewed the file and I agree with you. It appears that everyone was properly served and that the parties who failed to answer are hopelessly in default, and therefore there are not any claimants other than the claim by the sheriff for the costs and fees associated with filing the interpleader, which I think are reasonable under the circumstances based on documentation that was provided. And so the order that you guys submitted, we will go ahead and get on file, and then it will, what I think what my order typically says is y'all pay the money in, and then we'll order the clerk to pay it back, pay the 4,000 to you, and the rest of it will just sit in the clerk's office in the registry until someone makes such an application as you outlined a moment ago. So everything's fine, and we will be able to get that order on file for you today.
Thank you, Your Honor. I appreciate it. Have a
Thank
good
you.
weekend.
Have a good day, Mr. Fenimore.
Take care, Mr. Brehoff.
And Mr. Knight,
Yes.
EJ Capital versus Rashida Bay.
Yes, Judge. This is a strange case. This is a quiet title action in which the defendants previously owned a home that's now a rental home. And back in 2010, there was a quiet title petition that was filed in Fulton Superior because they paid property taxes, and the taxes were sold, and there was an order that was issued in 2012, 11 years ago, saying that they've lost title to the property. It was eventually sold to my client, who's had it since 2016. The defendants came in 2023, 7 years later, and filed a transfer where she transferred the property from herself to her trust, and then filed a dispossessory action in Fulton State Court, Fulton Magistrate, which we went and had a hearing on back in August.
Trying to dispossess your client's
They tried to
tenants.
dispossess my client. The court took judicial notice of the quiet title action, said you're not the owner, dismissed those claims. Now, and at the hearing, I said, listen, will you cancel your deed? If not, we have to come and file this action. And she said she'd think about it. She lives in Tennessee. Never heard from her. I emailed her. Never heard from her. So we had to file this action. We served her, Judge, personally, Ms. Bay and her trust, both on November 9th, 2023. No answer has been filed. We filed on January 10th the certificate of default and our military affidavit. And therefore, Judge, we request, we're not asking for damages because we know we won't be able to collect them. We're just asking for an order, quieting title, and canceling her, we'll call it the fake deed.
Right. Yeah, and I did have a chance to look over the file, and you're right, it is a little bit odd.
Yeah.
But sadly, that's what happens when nobody actually does anything with property that passes through 2 or 3 people having died, and nobody ever does anything about actually properly constituting the title and getting it put in a living person's name who's entitled to have it. In any event, everything that you submitted did look okay, and so we will go ahead and grant the relief that you're seeking and get that order on file.
Right.
And that you'll have your order probably tomorrow. Well, no, today's Friday, so it might be Monday before it's actually accepted, but we'll get it on file for you today.
Right. Thanks so much. I hope your sister's doing okay.
Thank you, Mr.
All right,
Knight. I
take
appreciate it. It's
care.
good to see you.
Likewise.
Take care.
Here, thanks, Mr.
And Mr. Robinson, we're a little ahead of the game, so I see you're still sitting there. If you're ready to go ahead, we can go ahead.
We are, Your Honor. We were spying upon you as you were clearing the docket. So
well, I have to say, it might be the first time ever that we're ahead of schedule instead of behind. So I'm glad that it was to your benefit, Mr. Robinson.
Good deal. Good deal.
Okay, so here's I'm going to tell you briefly what my understanding is, and then you can make your presentation regarding damages. My understanding is that there was an issue with plumbing associated with Mr. Robinson's home that resulted in some sewage issues. I'm sorry, you're Mr. Robinson, your client, and that your client undertook to have the problem diagnosed to see what the problem was, and it turned out that it was something associated with either a problem that was known or failed to be repaired or warranted against in some way. That's just the general strokes of what your original petition was. I think I understood that ultimately you guys settled on the particular defendant, Mr. Flynn, in this case, and that although there have been some very ugly communications back and forth, which I'm a little bit aware of in the file, that Mr. Flynn has been properly served and has not responded to the complaint, and more than 30 days has passed since he was, more than 15 days has passed since he was supposed to answer the complaint. So as a matter of law, he is in default, but because this is a liquidated claim I need you to present damages to me, all of which you have already outlaid for me in your motion and in the materials that you have sent, including what I saw was a proposed order. So very much appreciate that. So I
Yes.
believe that all of your T's are crossed and all of your I's are dotted as to the actual default. And that really what I need to do now is just hear from you and your client regarding the nature of the damages.
Your assessment, Your Honor, is 100% correct with one important correction.
Yes, please.
The respondent's name is Alan. It's
Alan.
Errol, and
Okay.
you mentioned Flynn.
Wonder where
but-
Errol Flynn's like a famous actor from like way in the old days.
Yes,
Lord
no,
knows where I come up with things.
I figured that's who you were thinking about.
Forgive me. Well, thank you for that important correction, Mr. Robinson. But please
But-
go ahead.
Aside from that, everything else is on target. Your Honor, this is as you mentioned, this is a construction defect case where the new homeowner, who is his official name is First Sergeant Akil Sanders. I call him Sergeant Sanders for your purposes, but between me and him, I call him Top because I am
Okay.
formerly in the military and we call it a First Sergeant Top.
Okay.
And it's a military thing that and even though he's in the wrong branch, he's in
We won't hold it against him, will we, Mr. Robinson?
I represent people in the Air Force, even though I was in the Army. So this is a construction defect case wherein Sergeant Sanders purchases a home and moves in, and within 7 days, raw sewage is backing up into his home. And we find out what the defect is there's a large stone in the sewer lateral that runs from the home to the street. So anytime he puts paper products or there's a fair amount flushed down into the sewer system, it backs up into his home and he's cleaning up raw sewage from his home. So that's the nature of this case, and it's fairly straightforward. But and I hate to analogize it to the mouse in the Coke bottle. However, the mouse only gets in the Coke bottle so many ways.
Right,
So-
exactly.
So we have the large stone in the sewer lateral, and normally a new homeowner is not down in their sewer lateral putting stones in there. So that's what this case is about. So would you raise your right hand? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, so help you God?
I do.
Would you state your full name for the record, please?
Akil Hanif Sanders.
And you can lower your hand, sir.
Thank you, Your Honor. Sergeant Sanders, what do you do for a living?
I am active duty Air Force reservist.
Okay. Now, you know that the respondent is already in default, so I want to talk to you about your damages, okay?
Yes.
Let's start with your compensatory damages. As a result of the large stone in your sewer lateral, did raw sewage back up into your home?
It did. It backed up into our downstairs bathroom.
Okay. Your Honor, I have several exhibits. There's nobody to object to them. If you don't mind, I'll just go ahead and introduce them all. And
That seems efficient to me, Mr. Robinson.
okay, so Sergeant Sanders, I want to show you Exhibit 5, Exhibit 3, Exhibit 4, and Exhibit 1 and Exhibit 6. Do you recognize these exhibits?
I do.
Okay, are these exhibits that you gave me?
Correct.
And with respect to Exhibit 5, is it a large stone that is in your sewer lateral?
Yes, it is.
With respect to Exhibit 3, is this the money that you paid in order to have it diagnosed, line flushed, and scoped, or i.e. a camera going down the sewer?
Yes.
With respect to Exhibit 4, is this the quote that you obtained from Prime Plumbing for them to excavate, take out the stone, put the sewer lateral back in, and by the way, cut up about half of your driveway, the
Yeah.
concrete?
It is.
Okay. With respect to Exhibit 1, is this the letter that your lawyer sent to the respondents in an attempt to resolve this without filing a lawsuit?
It is.
Okay. And with respect to Exhibit 6, are these the attorney's fees that you have incurred as a result of having to file a lawsuit in order to resolve this?
Yeah.
With each of the exhibits that I gave you, with the exception of it being a copy, is it a fair and accurate representation of the document that I described?
Yes, it is.
Your Honor, we would move Exhibit 5, 3, 4, 1, and 6 into evidence.
And without objection, those documents are admitted into evidence.
Okay. Yeah, Your Honor, now Exhibit 5 is a picture of a big rock. Would you like to see it?
Yes, please.
Okay. All right. So then do you mind if I share screen?
Please go ahead.
And I sent these to Mr. Freehoff, but I am happy to share.
I believe I have them by email. And so I can, if you're prepared to share them by screen, I'm happy to look at them. But I do believe I have them by email, and so would be able to reference them if I needed to. Go ahead.
Okay, I am absolutely prepared, Your Honor. Give me 1 second, and I will share screen. It'll give me an opportunity to flex my skills, which are newly learned, by the way.
It's an important skill we've all learned. None of us knew how to do this 3 years ago, right?
We were having this conversation during the break, and I was explaining to Sergeant Sanders, you guys aren't going back. You spoiled that.
Not for civil. I mean, and mostly the civil attorneys really appreciate it. That, you know, it allows you guys to attend to a lot more. I remember when I was a civil attorney, you know, having to go, you know, I was explaining to someone, you know, you'd have a 15-minute hearing, but by the time you got in your car and drove to the courthouse and found a parking space and got inside, and then you waited for the hour that it took the judge to call your case and all that stuff, you're 2.5 hours in for what was a 15-minute hearing. So
yes, and I the only challenge, Your Honor, for old schools like me is that when I've got a case where literally there's facts on my side, facts on the other side, and it could go either way.
right.
The old school lawyer in me wants to be in the courtroom trying to figure out, you know, is there any way for me to push these facts? But that's you know, that's like an old carpenter with his hammer, so to speak.
Yep.
And that, you know, he thinks that by virtue of having the hammer available, he can resolve the issue, when maybe it doesn't take a hammer, but because that's what you've done all your life, you want to reach for a hammer.
Yeah, I sympathize with that. I think the only negative I would say is that I do think that you lose some of the collegiality and fellowship that you get from killing time in the courtroom, waiting on the judge to call your case and stepping outside to see if you guys can work something out. I do think there's a little bit of something lost there, but we'll find a way to make that better soon. I hope so.
We will, and I just think that where is it? This one, is the rock.
It's in the tab.
It's in the tab. Okay, here we are, and let's go.
Wow. That's a big rock. That's crazy.
That's part of the reason that we wanted to show you, Your Honor. This is not a little pebble that we would come in here and ask for this kind of money about. So Sergeant Sanders, based on having paid the plumber to come out and run a diagnostic, is this the large stone that was found in your sewer lateral?
That is.
Now, when your home flooded, did you have to clean the sewage out of your home?
Absolutely.
How much did it cost you to remove the sewage and the smell from your home?
About $95.
Okay. And did that include dehumidifiers and cleaning products and so forth? Okay. Now, after cleaning your home, the plumber who found this stone in your home, did he charge you in order to excavate and to diagnose this?
Yes, he did. As far as to send the camera down and flush the line,
Yes.
he did.
Okay. And how much did he charge you?
$2,200.
All right. And I want to go to Exhibit 3. Yes, Exhibit 3. And let's see if I can get to that. Come on, screen share and work with me. Let's see here. There it is. Exhibit 3. Here we go. So, what is this on the screen now?
So I made 2 payments to Mr. James Coberly, who's the owner of Prime Plumbing, of $1,100.
And is this the first payment?
That's the first payment, and then there was another payment. I think it was the
Okay.
1st and the 5th.
Is this the one that was made on September 1st?
Yes, it was.
Okay. And is this your second payment that's made on September 5th?
Yes, it is.
All right. So after you paid him $2,200, did he advise you that the builder had left that stone in the sewer lateral?
Yes, he did.
And did he explain to you what it was going to take to fix this?
He definitely did.
And did he tell you how much it's going to cost to fix this?
Yes, he definitely did.
Would you explain to the court what does he have to do and what does it cost?
So once we got him out there, the first time they came out, the first day they came out, they basically put a camera down there. This was actually right before Labor Day. They put a camera down there and they saw obstruction, but it was, you could tell there was a bunch of gunk in there. So after Labor Day, they had to wait for their special machine that would come and flush the line. So they brought that back out, and that's what cost the $2,200 was the special machine that flushed, because the initial diagnosis was done with just with our warranty company. So they came out because we called our warranty company. So then when they come out, they flush it and they find the rock. Then he tells me, well, this driveway is going to have to be basically cut up, dug up, which is, to get to a plumbing that's about 10, 11 feet down, you're going to have to cut a hole that's about 15 feet wide so that it doesn't collapse on somebody. So the whole driveway is going to have to come up. They're going to have to fix the plumbing, pull the rock out, refix the plumbing, and then put all that dirt back in there, which is obviously going to cost even more, because then now you got to think about putting the driveway back, as well as grass and all that other stuff. So.
Right.
Okay. So now is 11,500 what he quoted you to do the plumbing repair?
Yeah, that was just to do, because he was saying they would cut the driveway, dig the hole, fix the plumbing, put whatever dirt back, but they're not going to repair the driveway or repair the earth around the driveway so that it's made whole again.
Have you spoke to anyone to figure out how much it will cost in addition to this 11,500 to fix the driveway?
Yes, it's going to cost, for about $6,200, I think.
Okay.
67, 62, something like that.
Okay.
Does that include the concrete work and landscaping, or just the concrete?
Yes, concrete and landscaping.
Okay.
All right. So Sergeant Sanders, if my math is correct, with the 11,500, the 2,200, and the $95, are you asking this court for a compensatory damage award of $19,995?
I am.
Okay. And Your Honor, if the proposed order we sent in had 3 blank lines for you, and I afterwards I went back and did my presentation in the order of your lines.
Okay.
All right, Sergeant Sanders, let's talk about litigation cost and attorney's fees, okay?
Okay.
Did you try to resolve this construction deficiency without hiring a lawyer?
100%.
Please explain to the court what you did to try to resolve this without me.
So when this happened initially, you don't expect for this to happen. So we closed on the house July 5th. We moved in August 12th. August 19th is when we heard some gurgling in the pipes, and we were like, what is that? We didn't know. And I just thought it was something with the new house. And then next thing you know, we have sewage in our downstairs bathroom. So the first thing I did was I called my realtor to ask her about it. Well, we called the warranty company first so that we wouldn't continuously have plumbing issues. When the plumber came out, then I started calling my realtor. And once I started to talk to the realtor, I started to realize, and the plumber started to realize it was a much larger problem. So I reached out to the representative for the seller, and his name was John McLean. And I guess he was kind of like a project manager for this property. So I talked to him a couple of times. He seemed like he wanted to help. And he was really gung ho. I'm going to help you out. Da 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 da. I'm like, okay, great, please. Like, we've already had this diagnosed. They show a rock. I send him the pictures of the rock. He's like, well, I'm going to come and have the line flushed. I'm like, well, the line's already been flushed. There's the pictures of the rock. Like, I need you guys to come over and open this up and get the rock out of the line. Like, it's not going to move just because you come with your flusher. And so we go down the road of talking to him a couple of times and him telling us he was going to come out. Well, he never made it out there. So he was supposed to come on a Thursday. He never made it out there. So finally, on a Friday, if I recall correctly, because at this point I had tried to start to kind of get my ducks in a row with who do I need to contact to get this fixed, because obviously he was kind of hemming and hawing about getting out there to actually do something different than what I had already paid to have done. And then, so when that happened, he called me back, and I guess word got back to the seller.
And this is respondent Allen.
This is, yes, respondent Allen. The word got back to the seller via, because when I talked to my realtor reached out to the seller's realtor and told the seller's realtor what the problem was. And I guess she told Mr. Allen. I don't know how that communication happened, but I got a phone call from Mr. McLean that was extremely rude, where he's cussing at me and telling me I didn't effed up now. You know, you reached out to my mentor. Now we're not going to do anything. We don't care. You know, we're not on the hook for this. And just a lot. And I mean, and this is within, 10 seconds of me saying hello. Like, I couldn't even get a word out. And at this point, I'm like, this guy's not serious, right? Like, literally, you just sold me a house and it has a rock between my house and the sewer line. And, I had two small children, which that's a problem when you're trying to teach children how to use the restroom.
Yeah. Potty training is complicated when there's raw sewage in the bathroom.
100%. That's a little bit more complicated. You don't expect to have to throw those types of factors into it.
We didn't cover that.
Yeah. So I actually hung up on. And so that's when I was actually working through my military duties with Mr. Robinson on something else. And I was just here talking to him, and I spoke to him about what I was kind of going through. And so he was like, oh, I can send a letter for you easily. And, we can rectify that. And I was like, oh, this would be awesome, because I need them to know that this is serious, that I'm not just going to walk away. Because I feel like they didn't feel like I had any sort of resources to pressure them to do what they were supposed to do. So right. Mr. Robinson, he created a letter and sent it out to them. And then that's when, obviously we haven't heard anything back from them ever since. Well, actually, I take that back. After the letter was sent, Mr. McLean, now he emails back to Mr. Robinson, copies me on it, and his tone was a little different. However, it was belligerent towards Mr. Robinson, saying that Mr. Robinson was being disrespectful, And I had stopped all communications with him after what he said to me. So at this point, I'm just going through Mr. Robinson and just trying to figure out what the next appropriate action would be.
So Sergeant Sanders, I think I have the letter up here. Let me check here. I do. There it is. So Sergeant Sanders, in your testimony there, you mentioned a letter from your lawyer. Is this the letter on September 12th of 2023 that your lawyer sent to all of the defendants, including Respondent Allen?
Yes.
And down in the letter, did we specifically lay out that you had already paid $2,200, you knew what the problem was, and that it essentially needed to be fixed?
I did.
And in this, do you essentially tell them that as of the writing of this letter, the cost to fix this is approximately $15,000?
I did.
And were you genuinely trying to keep a $15,000 problem, a $15,000 problem?
100%. I was actually willing to eat the $2,200 for the diagnosis of the problem just to get the problem solved. And nobody wanted, it didn't seem like anybody wanted to help me. So,
Okay. So after Mr. McLean had his second act of belligerence in response to my letter, did you conclude that you didn't have a choice but to file a lawsuit?
that's exactly what I concluded.
Okay. Sergeant, have you incurred legal fees and litigation costs as a result of this construction defect?
Yes, I have.
All right. I want to show you another exhibit. Let's see here if we can get to, there it is. It moved again. Okay. So Sergeant Sanders, I'm going to go to the end of the invoice. Which it looks like only 2 pages scanned. Oh, it's on the right side. I'm sorry. Let's see here. There we go. I'm sorry. Sergeant Sanders, as a result of all of the work put into this case, have you incurred attorney's fees and litigation costs of $16,605.91?
I have.
Are you asking this court to award these litigation costs as a result of the defendant's refusal to fix your home and your need to file a lawsuit?
Yes.
All right. Now let's talk about punitive damages. Sergeant Sanders, you've asked for punitive damages in your complaint, haven't you?
I have.
Do you believe that Respondent Allen acted recklessly or with indifference to the construction defect that was causing raw sewage to back up in your home?
Definitely indifference.
Would you
and
please,
recklessly.
would you please explain to the court why you think that?
Well, the fact that I actually notified them, I mean, I just wanted it fixed. So when I'm talking to Mr. McLean, you know, I thought he was going to fix it. I even went as far as to get Mr. McLean. I had the plumber that came out and diagnosed it, who's from Prime Plumbing, and they do large residential plumbing. And he actually called Mr. McLean to explain to him how much it was going to cost to fix that problem. And Mr. McLean ignored that as well. So, you know, and at some point I just felt like I didn't have any choice but to hire a lawyer. Because I even when I was discussing it with Mr. McLean and several conversations that I had with him, I was like, I just really need this fixed. I don't really, you know, like we can't live in a house that doesn't have proper plumbing. And so he was like, well, I'm going to tell you, like, you know, I can just tell you that I'll try to do what I can for you, but the sellers really don't care. Like once they're done, they're done. And I'm like, well, that's not the answer. I was like, because if that's the answer, then I'm going to have to get representation. Like I'll have to get a lawyer. And he's like, well, you know, we do this a lot and we're not really worried about lawyers. Like, and so I'm like, that doesn't make it like that. And so for me, I'm like, well, okay, if that's your stance, then that's what I'm going to have to do, because I'm sure that the law doesn't allow you to sell a house to someone and 7 days later you find out that the plumbing doesn't work from the street to the driveway into the house on the lateral.
So that the court is aware, how much did you pay for the home?
$440,000.
Okay. And is this a newly constructed property?
Newly constructed property. Not that I had constructed, they constructed it, and then I found it. And when I actually found it, so one of the problems was before we even closed on the home, when we found it, the access points on the lateral plumbing, one closest to the house and one probably about maybe 10 feet off the street, were at about 3 feet high, and they didn't have caps on them. So that was something that I noticed prior to even buying the house. So we actually put that in the contract as an amendment that they cut those down and actually cap those access points. And so they did that, and then obviously we realized that there was something in those access points moving forward. So
Is the result of this construction defect that you can't put paper products in the toilet?
Yes, we have not been able to flush paper products down our toilet since August, since the middle of August. So that's been our, and then what we did was, because we have kids, like, it's really weird because we have kids, we went and bought the single ply stuff, the stuff that's supposed to be biodegradable, and we've
The
taken and put
awful, horrible toilet paper that nobody wants to
horrible
use.
stuff that you
Yeah.
gotta get like tons and tons of it. And kids make mistakes, so they have done it, and it's really weird because now my daughter's 3, so she's just potty training. And she's good at it, but she can't flush toilet. So it's when we're in a public place, she always asks me if she can actually flush toilet paper down the toilet because she's not used to being able to flush. And it's not good because we just went through the holidays and we had guests, and my son had to write a sign on the wall that
Right.
and it's kind of third worldish, where you can't flush toilet down, in a brand new.
I was just gonna say, especially in a very nice brand new home, that's just not what you expect.
100%. Correct.
Sergeant Sanders, did you, in your discussions with Respondent Allen, did you learn that he has other construction projects?
Yes. So at closing, Mr. Allen, that's the only time I've met Mr. Allen was at closing. And he told us that he's planning on, he had about 7 or 8 different properties in that area because it's on the west side of Atlanta, which is obviously starting to kind of have a little bit of a
Big
renaissance.
growing, yeah.
And it's starting to grow. So they're going around and finding properties and building houses. He also owns a bunch of Airbnbs, and lots of I think he said like 28 Airbnbs. So
I asked that question because is it your impression that this is his first rodeo, or he just was indifferent to your situation?
Oh, it was definitely that he was just indifferent. I was told that he was indifferent. So now there's nothing for me to believe that he's indifferent because he has only shown me what they told me.
So, Sergeant Sanders, as a result of your experience and the indifference, are you asking this court to award $15,000 in punitive damages for the respondent's reckless and indifferent conduct?
I am.
Okay. Now, Sergeant Sanders, if we've discussed compensatory damages, wherein you asked for $19,995, we discussed litigation costs and attorney's fees, wherein you asked for $16,605.91. And we've now discussed that you're asking the court for $15,000 punitive damages. If my math is correct, are you asking this court for a total of $52,212.54?
I am.
Sergeant Sanders, is there anything that I've left out that you think this court should know in making the decision?
Not to my knowledge.
Okay. Your Honor, are there any questions we can answer for you?
No, I think you've laid out your client's position and requests very clearly. I appreciate that very much. Go ahead.
No, I was going to say that I'm going to stop sharing my screen, and
Okay.
I'll respond to anything that the court needs us to.
No, I don't think that I have any questions. I think that you smartly gave me a little bit more information about the basis for the punitive damages award, because obviously it has a higher standard or caliber quantum of why one would be awarded. The compensatory damages seem very straightforward, as do the attorney's fees. And under the circumstances that have been laid out for me by Sergeant Sanders, it does appear to me that punitive damages would be justified here. And so I'm willing to grant them. And so what I'm going to do is enter a default judgment, a final default judgment as to Errol Allen, or Allen Errol, still not sure which one's which, but as to the named respondent who failed to respond, who is in default. And I will enter compensatory damages in the amount of $19,995. Attorney's fees in the amount of $16,605.91, and punitive damages in the amount of $15,000, for a total judgment amount of $52,212.54. And as I said, I do believe that you sent over a proposed order. And so what I'll do is take a look at that order, and then edit it as I need to, and insert the numbers. And then we'll get that on file for you, probably by Monday.
Thank you, Your Honor. And
Okay.
we're not being rude, but we will be radio silenced for 30 days because that's the period to file an appeal. So
Of
we'll be
course,
radio silent.
absolutely.
And after we do our radio silence, we'll get into post-judgment dancing.
Okay,
And,
excellent.
And it looks like we've got some B&B properties and some new construction where we can set up a dance floor. If you
I was
want.
gonna say, it is nice that it looks like there's a possibility that you might actually be able to recover it. So often these judgments are just pieces of paper. So I'm sorry that you've had to deal with that. You're just lucky. So many people deal with these kinds of issues and just don't have the resources or access to an attorney. So I'm very glad that you were able to find Mr. Robinson and get some assistance. And so I wish you the best of luck with your family.
Thank you, Your Honor.
Take care.
Your Honor, that concludes my business. May I be excused?
Yes, sir. Have a good day.
All right. Have a good weekend, Your Honor. And
Thanks. Take care.
I hope that your reasoning for being at the hospital comes out okay.